I'd like to begin with the employer's first point on cross-appeal. I know it's a little unusual because I'm standing up here doing the appellant's argument, but it's why the Eastern District transferred the case to this court and why the Chamber of Commerce filed an amicus brief. In Section 287.170 of the revised statutes, the workers' compensation law provides that temporary total disability benefits, quote, shall be paid throughout the rehabilitative process. While older decisions, beginning with the Vinson case in the Court of Appeals in 1991, held a reasonable interpretation of this was that the benefits must stop at the point of the employee's so-called maximum medical improvement. In 2005, the General Assembly amended the workers' compensation law to require, in Section 287.800, that all its provisions be strictly construed. The temporary and total disability statute, 287.170, does not mention any requirement that benefits stop at maximum medical improvement. Instead, it requires that they continue throughout the rehabilitative process.
So in what instances are you suggesting the rehabilitative process would continue beyond maximum medical improvement?
In this case, the Commission answered that pretty well, and it's pretty emphatic language. The Commission, of course, deals with these cases on a day-in, day-out basis. They say that in a case where the employee's condition does not appreciably improve or even worsens, such as this one, despite further surgeries, applying a per se rule that temporary total disability benefits cannot be awarded after the date of maximum medical improvement, that is, when he stops improving, not when the rehabilitative process is over, works an absurd result. It's especially true here where the rule would require us to ignore the uncontested expert testimony.
So are you basically arguing that you can't know until after the fact whether you're going to keep getting better or not? You'll try treatments and at some point they quit working and you can't retroactively look back and decide when he got as well as he was going to get?
As a matter of fact, yes. I mean, it's a question of fact. And in this case, Dr. Johnson, Mr. Greer's Washington University surgeon, testified that Mr. Greer, when Mr. Greer was released from his care in February 2011, only then did his rehabilitative process end. And it's not a question of, did he get better after the surgery or not? It was what care was required. He remained under the doctor's care. And the Commission, it's pages 58 to 59 of the legal file, goes into great detail about this. Nothing in Chapter 287 would preclude, which is what the other side's arguing, that it precludes an award of temporary total disability benefits covering a healing period. I mean, that's what we're really talking about, is the healing period, not maximum medical improvement. Did the surgery make him better? Something like that. Because in this case, Mr. Greer is, to this day, as the record plainly shows, in a pretty bad state.
There's no dispute that the phrase maximum medical improvement does not appear in the workers' compensation law. But the absence of that phrase from the statute does not require this court to overturn the years and years of precedent, setting forth different standards with respect to when temporary disability ends and permanent disability begins. We're talking about strict construction. This court recently, in the Templemeyer case, told us what that means. The court held a strict construction of a statute presumes nothing that is not expressed. The operation of the statute must be confined to matters affirmatively pointed out by its terms and to cases which fall fairly within its letter.
Do strict and liberal construction require any different result if the statute is unambiguous by its terms? You have to construe it the same, whatever kind of construction you put on it, don't you?
You're right, Your Honor.
Don't we just look at the language of the statute? And I understand these earlier cases said maximum medical improvement is a reasonable, they seem to think it's a reasonable interpretation of what the statute means, but why don't we just look at the statutory words instead of fighting over what's meant by what some court said?
I'd love to do that, Your Honor.
So tell me what the statute says and what it means and how you think the statutory language applies here.
I'd love to do that. So we start with what is temporary total disability? 287.170.1 provides for temporary total disability benefits as follows. It says, for temporary total disability, the employer shall pay compensation for not more than 400 weeks during the continuance of such disability at the weekly rate of compensation in effect under the section at the time of the injury. The legislature did not define the word temporary, so we have to look to the plain meaning of that word. We can look to the dictionary. The New Oxford American Dictionary defines temporary as lasting for only a limited period of time, not permanent. If you go on dictionary.com, you'll find this definition: lasting, existing, serving, or effective for a time only, not permanent. My dictionary that I like to use, I got as a gift for my 11th birthday. It's the New World Dictionary, or the Webster's World Dictionary. I took a look at that one, and it says lasting, enjoyed, used, etc. for a time only, not permanent. So the plain language of the word temporary is something that is not permanent. The legislature did define total disability in 287.020.6 as the inability to return to any employment, and not merely the inability to return to the employment in which the employee was engaged at the time of the accident. So the plain meaning of temporary total disability then is the limited, not permanent, period of time when an injured worker is unable to return to any employment.
My concern about your argument, and I'd like your answer to it is, how do you know what's maximum medical improvement except by looking back and saying you quit getting better? And wouldn't that mean you don't know if some surgery or other treatment's paid for until after it's already done?
Well, I think what's important, Your Honor, is that first you have to prove, and it is the injured worker's burden to prove, that he has a temporary total disability. And as I said, the plain language of the meaning temporary is something that is not permanent. The legislature clearly contemplated a time at which a temporary benefit ceases to be temporary and becomes permanent.
And how did they guide us in figuring out what that time is?
The legislature did not guide us in that regard, Judge, which is why, as
they say, rehabilitative process?
Well, the rehabilitative process is not defined, and the rehabilitative process is only with respect to the duration when temporary total disability benefits are paid. That sheds no light as to whether or not somebody is suffering from a temporary disability. So we have to look to the...
I'm sorry, I'm not understanding, but I want to understand your argument. If they're still in the rehabilitative process, isn't that under the statute part of the temporary disability? Or is there otherwise I'm not quite understanding why that would be part of the...
Well, let's look at the facts of this case, Your Honor. The commission did held that the evidence was overwhelming that Mr. Greer was at maximum medical improvement. The evidence was overwhelming in that regard. He was awarded permanent partial disability for his disability for which the accident work was a prevailing factor.
What if the 2010 surgery had been helpful instead of unhelpful?
Well, those aren't the facts before us.
But how do you know till afterwards? That's what I'm saying. How do you decide something retrospectively?
That will be left to the ALJ and the courts, because it is undoubtedly a question of fact. And that's why when we go back and we look at these litany of cases, we don't just find maximum medical improvement. As counsel pointed out, we see words like healing period, the point of maximum medical progress. All of these terms the courts have used to define that point in time, and there is no doubt from the plain language of the statute that there is a point in time at which a disability ceases to become temporary and becomes permanent.